Your research fellow here at the Kyle Center. She will be talking with us about Arizona tribal water rights. How did we get here? This webinar is co-sponsored by ASU's Arizona Water Innovation Initiative. With no further ado, I'm going to pass things off to Cora, who will take us through the webinar.
Hello, everyone. My name is Cora. I am originally from the Navajo Nation, and I'm very excited to be here with you all today. I would like to share my Navajo introduction for those who are from the Navajo Nation. Yat she Cora Soyana Shia, Ado she Lokadana Nishle, Dos and Ajini Bashis Chin, Twitch Ini Dashache, Dokinachine Dashanale, Shanto Dana Sha Oko Hosote Shagan. What I have just shared with you in Navajo is my traditional introduction. I am of the Reed People clan, born for the Blackstreet Wood clan. My maternal grandfathers of the Bitterwater clan, and my paternal grandfathers of the Red House clan. I am originally from northeastern Arizona. I was born and raised on the Navajo Reservation in a small community called Shanto. And I currently work in the Phoenix Valley as a senior research fellow with the Kyle Center for Water Policy at the Morrison Institute, as well as through the Arizona Water Innovation Initiative. And today I would like to start by acknowledging, that I currently work and reside on the ancestral lands of the Acoma O'odham and Peepash people, and appreciate their contribution to our current Arizona water infrastructure through their construction of nearly 500 miles of canals in the Salt River Valley, a system that served up to 50,000 people at one time. These first canals laid the groundwork for the valley's modern canal system. As the visual shows, Arizona is home to 22 tribal nations, federally recognized tribal nations. From time immemorial, tribal nations have lived and sustained their lifeways in this region and continue to do so either on their traditional homelands or designated reservations. I am here with you all today to provide a unique insight into Arizona tribal water rights. This presentation was developed in context of federal Indian policy and law, because tribal water law has deep connections to history and the unique relationship to the federal and tribal relationship, which are inextricably linked to the United States ethical and legal obligations on this to the continent's First Peoples. My work has centered around promoting and protecting tribal sovereignty in both legal and policy environments, and I appreciate the opportunity to share this history with you. To start, as an overview, today we'll be sharing a overview of federal Indian policy and law, and then I have that as the background as we move into an overview of water law principles in general, and apply both of those backgrounds to tribal water rights in Arizona. We'll conclude and hopefully have time for questions at the end. But these layers of information are critical to understanding the field of tribal water law and the current context we find ourselves in Arizona. As I mentioned, federal Indian policy and law is a body of federal policies and laws that define and regulate the legal relationships between the federal government and the 574 federally recognized tribal nations and Alaska Native tribes in the US. This body of law is comprised of treaties, executive orders, statutes, federal court cases, and administrative decisions. Tribes and this body of law and policy acknowledges tribes as political entities and also acknowledges their inherent rights to property and sovereignty, and sets the structure for the federal and tribal relationship in the administration of those rights and the protection of those rights. I will highlight over the course of our time together the history of the United States' federal Indian policy, as the law has been both used as a sword and a shield in the quest of tribes to survive and protect its sovereignty from conquest and colonization over the years. This timeline represents the history of the federal government's official treatment of Indian people, but it should not be viewed as the exclusive or full incumbency, the full compensation of treatment of Indigenous peoples by the US government. It's helpful to think about this history as a pendulum swing. I first learned this going through the American Indian Studies program at ASU, and you can see that throughout the different eras of history, the federal policy has either promoted or outright eradicated and terminated their legal obligation to tribal nations against its predetermined ethical and legal obligations to protect tribal interests. During the 19th and 20th centuries, the federal initiatives to remove tribes from homelands punished Indians for practicing their religions, and the taking of tribal property in courts. The courts determined that these programs were either legal or unreviewable in the eyes of the federal government, and yet judicial decisions from the 1800s and 1900s also recognized tribal reserved rights to land, water, and self-government, and the supremacy of federal treaty rights over state laws, and the duty of the federal government to protect these tribal resources. Between 1789, when the first treaty was signed with the Delawares, to 1871, when Congress ended the treaty making period, the U.S. Senate ratified 370 treaties with tribal nations across the United States. These legal agreements between the two sovereigns, meaning the federal government and the individual tribe, created the Federal Indian Trust Responsibility. And the federal trust responsibility is thus a legal obligation under which the federal government is charged by itself with moral obligations of the highest responsibility and trust toward Indian tribes. This obligation was first described by Chief Justice Marshall in 1831 in the Cherokee Nation v. Georgia. And as I mentioned, this legally enforceable fiduciary obligation is on part of the United States to protect tribal treaty rights, lands, and assets, as well as resources, and the utmost duty to carry out the mandates of federal law with respect to American Indian and Alaska Native tribes, villages, and pueblos. This is one of the most important parts of Indian law and policy, and continues to be litigated over the years to either protect or attempt to diminish this legal and moral obligation on behalf of the federal government. During the same historical era as the treaty and reservation era, the United States also enacted laws that implemented policies encouraging settlement of arid Western lands and the development of scarce water resources that once was tribal Aboriginal territory. This included permitting settlers to homestead the surplus lands that were designated outside of federally reserved lands, when the federal government also allowed reservation lands to be broken up into allotments under the 1884 General Allotment Act and the Reclamation Act of 1902. So over the course of history, this disposition of land and therefore the assets that go with the land ultimately displaced many American Indians and across the United States, and here within Arizona, many tribes lost their Aboriginal territory, but continued to fight to be able to exist within their own communities and at times come back to their original territories. So as I described, the legal and ethical obligation of the federal government stems from a certain power. And this is important to understand that the relationship between tribal governments and the United States government is not one of a racial relationship, but one of a political and legal relationship. in the United States Constitution, Article 1, Section 8, Clause 3, which is sometimes referred to as the Indian Commerce Clause, the United States recognizes tribes' inherent sovereignty. The Constitution specifically obligates Congress with the power to regulate commerce with foreign nations and among the several states and with the Indian tribes. This constitutional provision has been litigated and interpreted by federal courts over the course of history, most notably the United States Supreme Court, to define the contours of the federal government's obligation to Indian tribes. But more often than not, it allows the court to refer the obligation back to Congress over Indian affairs. This relationship continues to define the federal trust responsibility and the federal government's position as a fiduciary to Indian nations. And this trust relationship is not merely metaphorical. In fact, many tribal advocates would be offended if this was deemed as a metaphorical relationship. It is an ongoing relationship as the federal government holds and administers billions of dollars of tribal assets in the form of land, natural resources, and cash for tribal governments. Again, I want to reiterate the point of tribal sovereignty. When we talk about tribal water rights, this is at the forefront of every tribal leader's mind and every tribal attorney and water manager and hydrologist. It's protecting the essence of tribal, the tribe's ability to govern and protect itself and its community and enhance the well-being and safety of its tribal citizens within their territories. And thinking of the trust responsibility and tribal sovereignty, we in the water law community understand the 1908 decision in Winters v. United States to be the cornerstone of Western water law in regard to federal Indian reserved water rights. In this Winters case was created out of what I think to be a repeat of history. You have this competing federal policy of encouraging settlers, non-Indians, to move out west for instance, with the Milk River in Montana, encouraging settlers to farm, as well as encouraging Indian people to farm as well. And so in 1888, the United States government created the Blackfeet, Fort Belknap, and Fort Peck Indian reservations along the Milk River Valley and opened up the remaining area to settlement. As most stories go, and as we've seen over history, we've had the encouragement of farming, which has led to overdevelopment. And in 1904, this area experienced a drought. So we had a situation where there was no water reaching federal diversion facilities along the Milk River, which led to litigation for the United States suing upstream users on behalf of the Indian tribes and in actuating the federal trust responsibility and protecting tribal rights within the river. And this led to, as I mentioned, the holding in the Winters v. United States Supreme Court case in 1908. What's interesting is that the Winters court looked at previous tribal water rights law, including women's rights, which recognized Aboriginal territorial rights to use water on traditional lands, and use that as precedent to guide them through creating their reasoning and eventual holding in Winters v. United States. This is as I mentioned, the cornerstone of federal reserved Indian water rights law, and in itself is based within federal law and continues to be as we practice today. The Winters case established the defining principles of Indian reserved water rights that continue to govern how we do water rights today. The Supreme Court also held that the establishment of an Indian reservation carries with it a reservation of water, and recognize that this implied water right is necessary for whatever purpose was intended by Congress in establishing any Indian reservation or federal reservation. And with this, the court also held that Indian tribes possess significant rights to water as of the date of their reservation establishment. And these rights that were established are not lost, even if they are not used. And these notions that were established in 1908, some may say conflict with the developing Western water law principles that we will get into later in the presentation. But what's interesting about the Winters Doctrine is that it places Indian water rights in tension with basic state water law principles. And as a consequence, the reserved water rights doctrine that was announced in Winters continues to be put in competition with private and non-Indian water users throughout the West. As we move to the connection of state water law, it's important that we understand these two layers of federal laws, not only the background of Indian law and policy, but also the Federal Reserved Water Rights Doctrine. Similar to federal Indian law, water law is a set of rules regarding water resource allocation and use. It's necessary to have an understanding of these different varying bodies of law in order to discuss Indian water rights, as non-Indian water law is primarily governed by state law. And during the early to mid 1900s, the United States entered into a period of mass water infrastructure development in the West to stimulate the depressed economy and to accommodate population growth in the West. Although these projects had affected tribal water rights, they were developed with little to no consideration or assertion of such rights. As a result, private water users, businesses, government entities have enjoyed the benefits of water development, while in most instances, tribes have been left wanting. This lack of development of senior tribal water rights within the basin, however, has created significant uncertainty in the Western system of water allocation and use. And because many tribes have not asserted their prior and paramount reserved water rights, many are able to utilize this water as non-Indian irrigation, and other commercial interests in many parts of the United States are concerned about the durability of their junior water rights. So with the development in the West, we have continued to see this uncertainty grow as we navigate in a time of climate change and unknown precipitation and snowpack runoff within the Colorado River Basin. As I mentioned, to provide an overview of Western water law, when we talk about water law in the West, we are mainly and predominantly discussing the prior appropriation doctrine, which, as many people may have heard, is the first in time, first in right legal regime. And a principle of the prior appropriation doctrine is the beneficial use principle, which allows water rights to be granted for specific beneficial purposes. Regulation of these rights and the permitting of these rights is issued by states and through water permits, usually through state water department or board. And adjudication and administration of state water rights goes through the state courts. This figure on the right shows a visual of what we mean when we talk about senior users versus junior users in a water system where you have a senior user downstream from the headwaters in a time of shortage or drought, being the senior user who has put the water to beneficial use first in the prior appropriation system. They would be protected in times of shortage, and the junior users for lack of better term, being late to the party, would see the first cuts in their water. And so when we look at the field of water law within Arizona, that is why we have the water adjudication system to help not only define the contours of priority and who's a senior user and who is a junior user, but also what quantity of water these users are using within the river. As I mentioned, a part of the legal regime when we talk about tribal water rights, there is a number of bodies of law that continue to contour what tribal water law is. And for many people, tribal or non-tribal, the Colorado River Compact of 1922 is seen as the cornerstone of Western water law, in context of the Colorado River Basin. The primary intent of the Colorado River Compact was to provide for the equitable division and apportionment of the use and waters of the Colorado River system. By 1922, prior appropriation was established as the law of the land in the West, and each of the Colorado River Basin states, meaning those who took the water from the river, would have senior water rights, and water developments that followed would be subordinate to those senior water rights. If there weren't enough water to fulfill all the rights, senior right would get water before the junior. And so these primary intents had allowed the 7 basin states to come together to define the relationship between each other and how the water was allocated within the river system. It defined not only how much water was being apportioned to each state, but also defined the relationship between the upper basin states and the lower basin states within the Colorado River Basin. However, in 1922, leading up to the compact, the states could not agree on how the waters of the Colorado River Basin would be allocated among them. So the Secretary of Commerce, Herbert Hoover, suggested the basin be divided up into the lower and upper half, with each basin having the right to develop and use 7.5 million acre feet of the river water annually. And this approach reserved water for future upper basin development and allowed the planning and development of the lower basin to proceed. However, the compact deliberately avoided incorporating allocations for Native American tribes, who remain largely cut out of decisions about the Colorado River management legally in the text of the compact, and in too many cases have not gained access to their water rights within the basin because of the limitations of the legality of the compact. As I mentioned, within the Colorado River Basin, we have the upper and lower basin, which is demarcated at Leith Ferry in northern Arizona and southern Utah. Within the Colorado River Basin, we have 30 federally recognized tribes, and on paper, legally, tribes have rights to about 20% of all the water within the Colorado River watershed. The river's current management guidelines, which dictate how the biggest reservoirs are run and how the water is managed in times of shortage, are set to expire in 2026. So currently you may see within the media stories about how the different states are proposing how the river should be managed in the future. Tribes have also mentioned that they are working on proposals as well to be included within this process. Ultimately, the federal government, the Bureau of Reclamation, would decide how the river is going to be managed. I like sharing this visual because you can see the different tribal nations within the Colorado River Basin, and you can also see how for some tribes, depending on where they're located, they are placed in a situation where their interests are very different as opposed to other tribes and other users. interests and priorities that may concern upper basin tribes may not be the same interests and priorities as lower basin tribes. And you also have tribes like my own, the Navajo Nation, who are a part of both the upper and lower basin. And so you can see how the management of the river may complicate things for different tribal communities. And I highlight this point because when we talk about tribal water rights, there's not a indigenous tribal nation approach to this water, to these water challenges that we experience it. And it's important to highlight not only within the work that I do, but I hope for water advocates and attorneys and people who care in the community that each tribal interest is highlighted and included within conversations and understood at all levels of conversation and policy development. We have seen throughout history when we are not inclusive and we are not having everybody at the table, how water policy and laws continue to perpetuate unfair allocation and water usage within the Colorado River Basin. Shifting a little bit more specific to Arizona, it's important to highlight our water supply. As I mentioned, the 1922 compact apportioned water to each state, and Arizona was entitled to 2.8 million acre feet within the compact. And so annually, this is what the state of Arizona is allocated from the Colorado River main stem. And the visual shows how Arizona's water supply is divided up. And so you see 36% of our water supply comes from the Colorado River, 18% comes from in-state rivers like streams like the Gila, Verde River, San Pedro, Bill Williams, as well as 41% of our water supply across the state comes from our groundwater reservoirs and aquifers. 5% of our water portfolio does come from reclaimed water. And this is the picture of Arizona water supply across the state. And so thinking about our water supply and shifting more to where our water usage goes, 20% of water in Arizona is used for municipal use, meaning cities and towns across the state. 6% is used for industrial use, and a large portion of our water is attributed to agricultural use, meaning the 72% of the water supply in our state going to agriculture and irrigation use across the state. In the context of tribal water supply, this is included within this picture. There are many tribes who use water for municipal use, agricultural use, and industrial use across our state. But we hope to continue to develop research to further define the specifics of the water use across our state over time. And so thinking about all of these different laws, federal laws and state laws, as we've layered to what ultimately will be a conversation about tribal water settlements, it's important to highlight the connection of why tribes are included within state water adjudication and management. In 1976, the McCarran Amendment was established by Congress, and it waives the sovereign immunity of the United States in state court general stream adjudications. What this means is that the federal government waived its ability to be prevented from state court adjudications and allowed federal claims to be heard in state courts. So when we think about the water adjudication and litigation within each state to define the priority and the use of all water users within the state, federal claims were brought into state court as well. And so by nature, tribal water rights being federally reserved water rights, they are also hailed into state court. Many tribal advocates rejected this because, as I mentioned, it is convoluting private water user rights and private rights with federally reserved rights in state court, but it also has been, by tribal advocate, has been seen as a diminishment of tribal sovereignty. It is, as a product of tribal sovereignty, we have tribal nations have the right to self-govern and protect their property rights, water rights being among them. And so being hailed into another sovereign's court was ultimately seen as a diminution of tribal sovereignty. And of course, with that became litigation. And so in 1983, tribal advocates had rejected this notion of being hailed into state court, and ultimately a case from the Supreme Court further defined what the picture of tribal water rights litigation would look like. So in Arizona v. San Carlos Apache Tribe, the Supreme Court upheld the state court jurisdiction to adjudicate Indian water rights where the United States was properly joined as a party and the state had adequate expertise and technical resources to adjudicate these claims. Initially, jurisdictional battles over whether federal parties could be required to prove their water claims in state courts reached the Arizona Supreme Court before it reached the United States Supreme Court. And what's interesting about this holding is that many tribal water law advocates have argued against this holding and in hailing tribal water rights into state courts on the notion of the Supreme Court deeming this jurisdiction on the fundamental aspect of having adequate expertise and technical resources to adjudicate these claims. And what I mean by this is when we look at water within Arizona and the adjudication statewide, you have several different adjudications going on in state court. Within the Gila River watershed, you have over 40,000 claimants and growing, and that in itself has over 85,000 claims and growing within the Gila River watershed. This was a state court water adjudication that was established in 1974. In addition to that, you also have the Little Colorado River watershed adjudication that was established a few years later in 1978 and continues to have thousands of claimants. And so we have one court within the state of Arizona trying to wrangle and manage all of these different claimants, in addition to federal claims and tribal water claims. And as I mentioned, the state water master and the state water court have to look at all of these claims and have each claimant come in, make their case and prove their water right, not only their priority within the system, but also their beneficial use of the water. And so when we think about water rights, tribal water rights within the general stream adjudication, there's so many different challenges that arise, not only by the nature of the water right, but the legal background that we've established in this conversation that we're having today of all these different layers of Indian law, water law, and federal Indian policy and law that many attorneys may or may not have the adequate education in. And so thinking about all of these different challenges and policies that interact within a general stream adjudication is something that has been critiqued over time. Looking across Arizona and into the purpose of our conversation today, you'll see on the screen on the left that we have about 14 tribes within the state of Arizona that have adjudicated their water rights and fully resolved their water rights. Going back to 1964, you have the first 4 tribes who were who had fully resolved their water rights in Arizona v. California, which is a Supreme Court case. Over time, you have a history of tribal water settlement negotiations involving the United States government, the state, and other users within the specific river system and water system that these tribal nations have occupied. You'll see that our most recent water settlement within the state is the Wallapai tribe. They have 2 water settlements as they have varying water claims on 2 different river systems. We have 8 remaining unresolved tribes who continue to litigate and also participate in tribal water settlement negotiations across the state, all with varying interests and priorities. And as I mentioned, when we look at how the water was adjudicated and allocated within the state of Arizona, you have a priority system that many of these tribal water settlements had to fashion with. So you have different water rights that have different water priorities within the Arizona water portfolio. And so when you take a look at how these different water rights were allocated to different tribes, and you think about the 8 unresolved tribes within Arizona, some of the water that has been already allocated within the system has to come from somewhere. And so most often than not, thinking about these 8 tribes and where their water would come from in an already allocated water system, stands to reason that there would be conflicts between tribes and conflicts between non-tribal users because the water has been allocated throughout the state. I also want to mention that with the first 4 tribes who had their water rights adjudicated in Arizona v. California, this case held that the only feasible and fair way by which reserved water for reservations can be measured is by irrigable acreage for the purpose of promoting a more agrarian lifestyle. However, this quantification standard directly conflicts with Western or Winters rights purposes. And what I mean by that, in the Winters case, the Supreme Court held that the essential purpose of an Indian reservation is to provide Native American people with a permanent homeland and an abiding place. And so when we think about the purpose of reservations and how we are defining our beneficial use for tribal nations, we are trying to define use for thousands of tribal members who are trying to create a permanent homeland. And so the water master and other attorneys within negotiations have to argue those certain aspects of defining what quantity would look like for each community. As we move forward, this visual stands to show the history of tribal water settlements within Arizona and comes from a very interesting news article published by ProPublica. And I really enjoy this visual because it shows how long it takes to ultimately resolve a settlement. And as I mentioned before, there are so many different challenges and nuances in regard to settling tribal water rights. It's not just about defining our quantity and our priority. It's about our sovereignty, and it's about nation building, and it's about our cultural and historical uses of our water that ultimately do not fit within the Western water law regime. And so over time, you see how different tribes have been able to work through those different legal systems, some sooner than others, as you see at the bottom of the visual, the 8 remaining tribes who continue to try to settle their water rights within the state have been working for almost 40 plus years in trying to manage this system. And I read recently that in the 1960s, thinking about due diligence and representation in these procedures in the 1960s, there were estimated about 25 Indian attorneys within the country. So thinking about how these proceedings had either excluded tribal communities' voices within litigation, and thinking about how, as tribal nations, we did not have our own people litigating for us and representing us in the state court, is really something I find interesting in this history. As we move forward, the purpose of this presentation, as I mentioned, was creating this timeline in comparison of the federal Indian policy timeline, as opposed to notable Western water law historical points. So you'll see, as I attempted to color code, on the left, you have the federal Indian policy timeline, and on the right, you have different points in water history that align with those certain eras of federal Indian policy. And in the formative years when the United States as a country was still trying to figure out how they worked with tribal nations and the sovereign nations that they recognized at the time, there was a lot of activity in the West. Most notably, you have the gold rush happening in California, which eventually led to the doctrine of the prior appropriation system, which we use within Western water law today. And we also have the United States acquisition of the Southwest region from the country of Mexico. And you also had explorers and settlers coming out west to survey the lands in which the United States acquired. And so it's always interesting to think about this history and what was happening to tribes during this time. As you move along in the timeline, when the federal policy was to assimilate Native Americans and kill the Indian and save the man, and really strip our culture and our identity from us as Indigenous people, and place us on allotments and force the individuality and individual property paradigm on us. You had a lot of the Western water laws being established during this time. So you had the disposition of land and water rights that attached to that, while the Winters case was being established and Federal Reserve water rights was barely getting on its feet. In Arizona, you have the 1910 Kent Decree, which helped birth the Salt River Project system. And then you also have other water infrastructure being completed throughout this time. What's interesting and something that I think about a lot is while we are going through this process of tribes going through this process of defining our relationship with the federal government, the state of Arizona came into statehood in 1912, and a few years later, the Arizona Surface Water Code was established. And then, you know, as I mentioned, we have the different Western states arguing and trying to resolve how much water they receive from the Colorado River, and the eventual development of the Colorado River Compact. And while all of this was happening, tribal members in the state of Arizona and across the country were not considered citizens. So you have 3 eras of federal Indian policy of the federal government trying to define what their relationship is with tribal nations and how they are promoting or hindering their trust responsibility, all while tribal members are not even considered citizens of the United States. 4 years later, you do have the Boulder Canyon Project Act, which again is in this era of assimilation, but is also a very notable point in Western water history. As we move into the next era of federal Indian policy, you have the era of Indian reorganization, which is, as I mentioned, a 180-degree shift in federal Indian policy, where assimilation tactics didn't necessarily work for many tribal nations. The resilience of tribal communities and tribal people allowed this to happen, and you have an era where the federal government is trying to continue to try to assimilate tribal communities into American culture by emulating systems of government that are akin to the federal system that we have today. So you have some tribes who had adopted tribal constitutions that outlined their governing system within their community, and others who rejected that notion and continued to use their traditional ways of government. But as a product of sovereignty, that is something that each tribe has the inherent right to do, and it is something that was not granted by Congress or any federal power, but is something that is natural and organic to each tribal community. As we move along in the history of the timeline, you see that the large-scale water projects in the West continue to develop, and different water laws were enacted during this time. As you get into the 1960s, you have the establishment of the 4 tribes in Arizona v. California and their water allocations within the system, and the birth of the Central Arizona Project. As we move forward in history, there are other notable parts of Western water law history. However, the slide was not big enough to accomplish all of those points of history, and it's something that we at the Kyle Center are very interested in learning more about and analyzing as we move forward. But I want to end here on the note that we have the incredible privilege of looking back on history and seeing how the river was managed and how water was allocated within the West and how infrastructure was developed. And I think it's important that we take the time with this incredible privilege to look back on the equitable nature of this allocation as we look to the future of our water policy and water management within the state of Arizona. But that is all I have today. I definitely appreciate the opportunity to share more about the water policy and federal Indian policy history within the state of Arizona, and hope to continue this research. I'm currently working on a tribal water settlement study that focuses on the 22 tribal nations within Arizona. As I mentioned, within the history of our water development within the state, you have had 14 different tribal water settlements being negotiated, and I'm excited to take a further deep dive into those settlements and compare and contrast, and ultimately show the impact of tribal water rights and its impact within Arizona water policy. And I'm sure we will all share that with you once that's ready to go. But for now, I think we are going to switch to questions.
Thank you, Cora. That was fantastic. I do not see any questions in the Q&A chat, so I'm just going to give folks a minute in case they want to type some now. And while we're waiting on that, we'll say that our next webinar is on April 22nd, and it will focus on our analysis of and tools showing how much water per acre is being used in different cities in Central Arizona. Grant Heminger is going to be our host for that webinar. I think it'll be really fun, so I hope you guys can join us. And to receive emails about Kyle Center events and reports, attendees can sign up right on the landing page of the Arizona Water Blueprint, which you can find by going to azwaterblueprint.asu.edu. Okay, I think we've had a couple of questions come in, so let me take a look at those. So from Rudy Fisher, he asks, how do you see the tribe's interests being taken into consideration in the post-2026 negotiations on water?
That's a great question. Thank you for answering. I understand that in the upper basin, you do have water commissioners who have invited tribes to participate in negotiations. And so by that, tribes have the direct representation in those discussions in the upper basin. As far as I'm aware, the lower basin has not taken that approach. However, tribes have also taken the initiative to develop their own proposals to submit to the Bureau of Reclamation to fully represent their own interests within the negotiations, which will expire next 2 years.
Okay, and from Lisa Kim, she is curious about the tribes who were granted rights in the 1960s. She asks if you have studied if those tribes that were granted rights in the 1960s requested enough water to grow their tribes into the future.
I think that's a complicated question. I definitely do not want to speak for the tribe and how they envision their future to be, but I do understand that they have utilized their water to the best of their ability. I think something that's interesting in water negotiations and planning for the future is just the uncertainty of water levels as we experience climate change, and also how that works for tribal governments is just the same. I do understand that many tribal governments, and those four in particular, do utilize their water along the river and have the ability to lease water to those in need as well. And so thinking about their specific needs on the reservation would be something that we would love to research, but at this time I don't have a clear answer.
Okay, and an anonymous attendee would like to know if you would like to comment at all on the Navajo Hopi settlement.
Unfortunately, as a former attorney of the nation, I'm not able to comment on that.
Great. And Melinda Whittington asks, oh, actually, she just says, really great job and thank you for doing this. It's not actually a question, and I agree. Let's see. Okay, so Felicia Fonseca asks about your insight into how various tribes are negotiating priority rights to the water. As you noted, tribes in Arizona were here first. But Wallapai, for example, recently negotiated for fourth priority rights in its settlement. Sorry.
Yeah, I think that's a very timely question, and something that many tribal attorneys and tribal leaders are advocating for. As you mentioned, this system that has been predicated on the first in time, first in right regime, in actuality is being managed and deployed in a different way. And so thinking about how the water has been allocated throughout the state does bring up those questions of priority. And I think many people who have built their livelihoods and depended on the water supply now ultimately have a big say in those discussions as well. But I think as we think about tribal sovereignty, as we think about tribes' inherent rights to create their permanent homeland as designated by the Supreme Court, these are very important questions that many negotiation meetings have to think about, and as well as many federal agencies have to think about. I think from a tribal advocate perspective, of course, every tribe would want the highest priority water as was designated by their reservation date. Not only is that embedded within the law, but that is something that the federal government as a trustee to each tribe has a duty to protect and promote within these negotiations. However, I think as we're experiencing these different tribal settlements, many tribal governments do see that the impact in the impact of water history, water infrastructure development, and water use within this, not only within the state of Arizona, but within the state, within the Colorado River Basin, is that many people have benefited from the water, and many tribal people live within cities across the state and go to school, to universities across the state, and are very aware of how much benefit their water has given to the state of Arizona.
Okay, Denish Tung notes that some of the Navajo Nation abuts the Colorado River, and he was wondering if those that own this land are able to use water from the Colorado River for natural or artificial uses.
I think the land that abuts the Colorado River and the Navajo communities that live along there traditionally have used the water. We have many stories of our ancestors and grandparents, great grandparents traveling down to hike into the Little Colorado River and Colorado River confluence area, and to different salt mines within the Grand Canyon to access salt, which is a very important cultural component within our ceremonies and within our religion and our daily lives. And so a lot of those communities who had ventured down there continue to live there today. I don't know if they can continue to do that. I'm sure that those who practice that traditional lifestyle probably do, but there is water infrastructure in those communities, and there are different ways those communities do receive water, either if they water haul or have water infrastructure there in place.
And I apologize, we're not going to get to every single question because we are quickly running out of time. So one last one, Steve Fernandez asks if whether tribes have negotiated their water allocations in exchange for future allocations or some other form of compensation.
Yes, I think that some tribes have taken that route. For some, the idea of going through a settlement versus litigation, and one of the benefits of going that route is being able to negotiate different aspects in addition to having water access and wet water for their communities. They also are able to negotiate different aspects like money or water infrastructure development and cost share provisions with federal and state parties. And so some tribes have gone that route, but as I mentioned, each tribe has a different priority and different interest in water, and some may wholly want access to their water in general, and that may include cost shares and money from the federal government's perspective in order to continue to uphold their trust responsibility in making sure tribal communities have water to live on their permanent homeland.
Okay, I'm sure you will all join me in thanking Cora for such an excellent presentation. Again, our next webinar is April 22nd, and we are going to be talking about land use and resulting water use intensity. So that should be a fun one. I hope you tune in for that as well. And thanks once again to ASU's Arizona Water Innovation Initiative for co-sponsoring this webinar. Have a great day.